In our two previous webinars, we discussed the complementarity of the treaty, maps, and mandatory human rights due diligence and legislation, as well the meaning of the treaty in different regions of the world and provisions for that need further discussions. My name is Marina Novaes. I'm a researcher and representative of the Resource Center in Brazil. And we are a large organization with over 80 people working to advance human rights in business and eradicate abuse. So I will speak a bit about the Brazilian perspective and why the treaty is important, especially in terms of access to justice. The tension between business activities and human rights is not a new issue. And for many years, popular movements around the world have been denouncing human rights violations committed by transnational corporations. At the heart of the issue is the fact that although human rights violations by transnational corporations through their supply chains are evident, states are usually unable to hold the culprits accountable or provide access to justice and compensation to victims because they are influenced by corporate interests and face economic sanctions when they seek accountability. At the international level, the United Nations Human Rights Council leads to two parallel initiatives to restrain the normative framework of human rights and business. One that led to the creation of the Working Group on Business and Human Rights, whose mandate is related to dissemination and implementation of the UN Guiding Principles on Business and Human Rights. And the other concerns the drafting of an international treaty on the subject, which is currently in the stage of discussing an updated draft. In the Brazilian context, the first attempt to incorporate the guiding principles into Brazilian law occurred in 2018 with the publication of a decree, but was imposed without the participation of civil society in general. This decree, based on the voluntary adherence by companies, was named the National Guidelines on Business and Human Rights, but it is also lacks binding force. While these regulatory acts represent a step forward, they were insufficient due to the voluntary nature in the process of shifting the paradigm regarding corporate responsibility for human rights violations and access to justice for affected individuals in Brazil. But we pin our hopes on the binding international treaty and the approval of a bill in the Brazilian Parliament, Bill 572, which aimed to create a binding national framework of human rights and business. In Brazil, we have advanced and recognized legislation of specific human rights issues, such as the law addressing protecting against modern slavery and international convention regarding the guarantee of free, prior, and formal consent of indigenous people and communities. These laws impose certain standards of conduct in the context of corporate activities in Brazil. However, Brazil's dual condition in terms of human rights, being advanced in normative terms, but is still vulnerable to various forms of violations, specifically within global supply chains, place the Brazil state in a privileged position at the negotiating table for an international binding norm on human rights and business. In this scenario, based on the Brazilian experience, I believe the potential contributions to an international treaty on human rights and business would include the assignment in domestic laws of defending the interests of rights holders through strong and independent public entities can perform the function both judicially and extrajudicially, within any type of procedure expense for victims of human rights violations, to facilitate effective access to justice, and to pursue a full compensation for damages. Also, the provision of a procedural instrument aimed at reducing resource asymmetry and ensuring a level playing field in disputes involving human rights violations by corporations. Moreover, the Brazilian human rights protection system has many weaknesses and that make the country vulnerable to violations and create room for corporate impunity. Often the judiciary is not adequately prepared to litigate and adjudicate cases involving human rights violations, either due to lack of expertise in complex issues of this nature or because of the absence of adequate legal procedures. So in the judicial proceedings related to human rights violations in the context of social environment disasters, mega sporting or entertainment events, issues related to access of justice are common, including insufficient participation of affected people, resource asymmetry between company and victims of wrongful conduct, and delay in resolve the demand. From a normative perspective, an international treaty on human rights and business, in addition to providing perspective, international treaty of human rights and business will be the way. There are other important points without the development of an international treaty on human rights and business that would be meaningless and which the Brazilian state cannot afford to neglect, including the primacy of human rights, reducing the impunity of transnational corporations, providing direct obligations for companies rather than just to the state, and most importantly, placing rights holders at the center of any situation in which business activities may affect them, ensuring at least the rights to information, participation, access to justice, and full compensation. In order for the treaty to fulfill the important role expected of it, promoting a real change in the paradigm of corporate abuse, an assertive text is necessary, one that represents a real advancement compared to what the UN Guide Principles and other non-binding international frameworks already provide. Only in this way, we can progress to be made in terms of reducing the impunity of transnational corporations and states for a global scale human rights violations. Well, I've talked enough, and now I want to pass the floor to our moderator for today, Carlos Lopez, who is a senior legal advisor and head of the Program of Business and Human Rights and International Commission of Jurists. Prior to joining the ECJ, he worked at the Office of the UN High Commissioner in Human Rights and in various capacities. So over to you, Carlos, and we all have a great day today.
Thank you very much, Marina. I think you have already, to a great extent, set the stage for the discussion of today and the discussions that we have had so far. So thank you again to you and to the colleagues from the Business and Human Rights Resource Center and the other partners in co-organizing the series of 3 webinars in relation to the treaty initiative. We are today, welcome to everybody, to the last iteration of the series, the treaty and access to justice for affected communities, addressing the human rights commitment gap. So for that, we have truly an excellent panel of speakers that I will introduce in 1 minute. But first, let me remind you, as Marina has done just a minute ago, that these issues in relation to obstacles to justice and the need to have a better access to justice are as old as the discussion as in business and human rights. The discussion of today, this is not the first one, not probably the last one that will address these issues. Over the last few years, or even before the guiding principles were adopted, there were a series of activities, advocacy activities, research, and publications in relation to the need to have better access to justice for cases of human rights abuse involving business enterprises. Most recently, the ICJ has teamed up with the Colombian Commission of Jurists, FIDH, and the European Center for Constitutional Rights to publish a very useful advocacy brief, exactly with some recommendations on how to overcome these obstacles to justice in the context of this treaty initiative. That publication in June this year, called Overcoming Barriers to Access to Justice, has been published and it's been used also for in a discussion meeting with several state delegations here in Geneva. In that paper, the organizations that prepared that paper and organized the meeting presented 4 recommendations, broad recommendations. First, a number of measures to overcome the financial burden that prevents many times the litigants and the victims to have better access to justice. Then, secondly, the recommendations go to provide a number of ideas on how to overcome the evidentiary hurdles and the burden of proof, and alleviate the burden of proof in relation to those obstacles to justice, especially in civil litigation, but also applicable to administrative litigation. Thirdly, the recommendations goes in the direction of providing or underlining the need for collective or group complaints to facilitate also the task and the work and exercise of rights by indigenous communities, poor communities in general, children, trade unions, and others that act as a collective and have collective rights rather than individuals. And finally, a number of measures to facilitate access to information and disclosure, whereby victims or potential litigants will have better access to information on the rights and options to claim justice, and also the information that may eventually be in the hands of the company and exclusively in the hands of the company, whereas it is instrumental for the backing, the support of the victims' claims. In that report, that brief has been very well received. I think there are 2 main messages from that discussion with the state delegations. The first one is that all these recommendations, as many others that have been issued in the past by other organizations, have a strong support in practice, regional and national practice, whether it is in the form of treaties, international soft law instruments, or also even regional jurisprudence by regional courts of human rights. Equally, we have a number, or we outline in this publication, a number of practices in terms of jurisprudence and legislation from the national level, national authorities. I think this is well appreciated and seen as a strong basis to consider this as what is spread practice and acceptable formulas also to discuss and insert in the new update draft. We have today with us, and now I will introduce the panel. As I said, we have an excellent panel with us, and I'm very grateful to have them here, and I appreciate very much their availability and the time they are taking to be with us. I know you're very busy, you run very busy schedules, but I think most of us, all of us, will enormously appreciate and be thankful for your insights into the assessment of the current draft. A couple of months ago, a new updated draft of the treaty has been published, and it's going to be discussed in the 9th session of the Intergovernmental Working Group on Business and Human Rights, on the Treaty on Business and Human Rights. I think this will be a very strong basis, a very useful basis for our discussion today. We have, as I said, a very strong panel. I will present them now, and then give them the floor after a short introduction. First, we have Professor Surya Deva, who is currently the UN Special Rapporteur on the Right to Development. He's a professor of the Macquarie Law School and director of its Centre for Environmental Law in Sydney, Australia. He served as a member of the UN Working Group on Business and Human Rights from 2016 to 2022. Next, we have Sasha Firabain. He's currently a senior program officer at the International Federation for Human Rights, FIDH, working in the Globalization and Human Rights Program and Environment Program. He has been working on the treaty process and has attended the Intergovernmental Working Group for the past 5 years. Therefore, he brings a strong load of experience with him. We have next Ruwan Subasinghe. Ruwan is a legal director at the International Transport Workers Federation, ITF, a global trade union body. He sits on the advisory boards of the International Lawyers Assisting Workers, ELAW, network and Cornell University's New Conversations project. He's also a board member of the Ethical Trading Initiative. Prior to joining the ITF, Ruwan practiced at Freshfields Brookhouse, Derringer, an international law firm. We also have the pleasure of welcoming among us Tony Salvador, who is a lawyer and works at a Third World Network, a non-profit international network of organizations and individuals involved in issues relating to development, developing countries, and North-South affairs. Additionally, Tony focuses on tax justice issues. He's part of the Global Campaign and a member of the Asian Task Force for a Legally Binding Instrument. Next, we have Letícia Aleixo. She's a lawyer and works for the Environmental Law Alliance Worldwide, where she collaborates with environmental and human rights lawyers around the world. Before that, she helped communities impacted by mining as project coordinator at Caritas Minas Gerais in Brazil, and carried out research on issues related to business and human rights, while at the same time working on human rights clinic of the Federal University of Minas Gerais. Next, on the other side of the globe, we have Sor.Rattanamanee Polkla, who is equally a lawyer and an executive coordinator of the Community Resource Center, a Thai-based NGO providing legal aid to communities who face negative environmental and social impacts as a result of development projects. She is also a coordinator of the Mekong Legal Network. Next, we have, last but not least, I should say, Erika Mendes. Erika is well known among us. She's a social and environmental activist from Mozambique, a member of civil society organization Justica Ambiental, where she coordinates the corporate impunity and human rights area and works closely with communities affected by extractivism and mega projects. She's been working on the process of negotiations for the UN binding treaty for the past 8 years, and is part of the global campaign to dismantle corporate power. She is also the regional coordinator for Africa of the Economic Justice Program and Friends of the Earth International. So I think we're gonna work with this excellent panel of speakers that bring with them an enormous wealth of experience, diversity, and representativeness with them. I'm very glad I'm privileged to be the moderator in this session. The session will unfold as follows. After this introduction, we will have an opening question to be addressed by 4 of the participants, Sasha, Surya, Ruwan, and Erika. And then each speaker will have to answer specific questions in relation to their specific area of expertise. So the format of this session, more than a series of presentations by panel speakers, this is an interview session. I will be formulating the questions, and we will be hearing the answers from the speakers, from the panelists. You will have also, we will have a last round of general questions for the remaining speakers, Tony Salvador, Sor.Rattanamanee, and Letícia towards the end, before we move to the questions and answers session, at which point I will hand over the mic to Elodie Ava from Business Resource Center, who will conduct the session on Q&A. Please, at that point, when the questions and answers session is open, please leave your questions in the Q&A icon, not in the chat, but in the Q&A. The chat is not monitored, so the Q&A will take into account and consolidate your questions. And please be concise and clear and address your question to a specific speaker or several specific speakers to facilitate the discussion. We have limited time, and I think I'm already well over the time assigned to me. So let me start with this panel. So welcome again. Thanks very much for the speakers, for your patience, in particular, after this long introduction. I have a general question for Sasha, Surya, and Ruwan, and Erika, taking advantage of the broad expertise of all these years. What is your general assessment of the provisions on access to justice in the latest draft on the legally binding instrument? So let's start with Sasha, please. Each of you has 3 minutes. Sasha, you have the floor.
Yes, thank you, Carlos. Hello, everyone. Thank you to the organizers as well. And thanks, Carlos, for starting us off by citing the paper that we jointly published in July on access to remedy, but also for mentioning that access to remedy is an issue as old as the business and human rights field. I think this, to start with, explain why we've been supporting so strongly the elaboration of a legally binding instrument on business and human rights. Because specifically, we think that one of the main added values of having this kind of treaty is to respond to challenges regarding access to justice, to respond to address a certain number of gaps in the international framework. To your question, our preliminary analysis is that the updated draft is generally, in terms of format, more streamlined, and some of the substantive provisions are clarified. Yet, in terms of content, unfortunately, the new draft makes some unfortunate steps back. It contains a lot of provisions on access to justice still, but there's also important gaps. I just want to cite 3. To start with, first, one of the key structural issues is that throughout the draft, you have numerous provisions that relate to or require consistency with domestic law or domestic administrative systems, which undermine, to a certain extent, the effectiveness of the provisions, and in a sense defeat the purpose of the instrument as an international binding treaty. The added value of the LBI is to set universal international standards, not to allow states to maintain lower standards in their domestic law, especially given the well-documented barriers in access to justice in current legal frameworks. The second is that in a lot of respects, the substantive scope of the instrument has been restricted. You see that with many mentions of the environment and climate, which have been deleted from the third revised draft. There's also a lack of mention of international criminal law or international humanitarian law, despite state suggestions in this direction. Drafters also deleted some language on conflict-affected areas. And another issue related to this is that Article 3.3 on the scope has been redrafted to write that the legally binding instrument covers, I quote, all internationally recognized human rights binding on the state party. And here there's two issues for us, but the first is that the reference to specific international instruments has been deleted, so it's not exactly clear which instruments fall under the scope of the treaty. Sorry, and then just the binding on the state party part, which would limit the scope of the conventions ratified by each state. And I'll talk about the liability article in the next point, which was my third point.
Yes, Sasha, don't worry. I think you are anticipating your next question, but let's stay on this general question at the moment. Let's move to Surya Deva, Professor Surya Deva. What's your general take, appreciation, assessment of this current updated draft in relation to access to justice?
Thank you, Carlos, and hello, everyone. I would sum up by saying that the treaty provisions have good intentions, but not so good execution. And let me start with the good intention part of it. If we look at Article 2, the purpose of this treaty, it rightly acknowledges, out of, I think, 5 clauses, the 2 clauses focus on the access to remedy element. Explicitly, this is mentioned that access to justice and access to remedy is one of the objectives of this LBI. This is good. There's also acknowledgement of mutual legal assistance and international cooperation in the purpose, which is also directly linked, in my view, with the access to remedy element. So this is a good start, because you identify very clearly why we are negotiating this LBI. I will also suggest that most of the articles, in particular Articles 4 to 14, directly or indirectly relate to access to remedy. So we should not see access to remedy only relevant or found only in certain provisions. I would see all of these articles relevant, and that is again kind of suggesting that access to remedy is a core thread of this LBI. But now let me come to the not so good executions in my view, and I will give a couple of examples and we'll stop with that. First is that the LBI uses 2 terminologies, access to justice and access to remedy. Access to remedy is defined, but not access to justice. What does it mean? Are we talking about 2 different things here? Are we talking about the same concept? Or access to justice is talking about access to justice or access to remedy through judicial means only, and access to remedy is wider, that will capture even non-judicial. So that ambiguity is there, and it is not clear. The second point, and I will stop with that, is my assessment is that the draft treaty as it is evolving is becoming like a hodgepodge, because you're trying to make adjustments once in this direction, second time in the other direction, because you're trying to accommodate different competing requests coming from different situations. And then the cohesiveness is lost. Let me give 2 examples. The treaty is following the legacy of UN guiding principles. They talk about adverse impact, but they also talk about human rights abuses, which is something which is the UN guiding principles don't focus that much on. But if you're talking about adverse impacts, then the concept of victims does not really make sense, because victims, the concept of victims, which is defined in Article 2, I believe, or the definition article, in fact, then that is more about abuses. So I think we need to clarify, are we talking about adverse impact? Are we talking about adverse or more than that, abuses? My second example, and I will stop with that, Carlos, is the business responsibility and the liability. So if you look at the preamble, there's this issue. They're saying that businesses have a responsibility to respect human rights. Now, if businesses merely have a responsibility to respect right, how come we are imposing liability on them? Because that is the pillar 2, that businesses have a responsibility. Now, if this treaty is not progressing and making it clear that businesses have an obligation to respect human rights, then are we making progress? Thank you.
Thank you, Surya. Thanks very much also for already taking us to the specifics of the treaty. Let's move to Ruwan. Ruwan, what's your general assessment of the access to justice provisions in the latest draft?
Yeah, well, thank you, Carlos, and thank you to the organizers for putting on this webinar. I'll follow on from Surya and Sasha's comments by saying that, of course, we need to take a holistic view when we look at the access to justice provisions, and starting off with the sources of rights available to rights holders and victims. And as such, I think Article 3.3 is problematic, as Sasha suggested. Indeed, from a trade union perspective, we don't even know what the status of fundamental principles and rights at work are, given this formulation under Article 3.3. Then, of course, if we talk about access to remedy, we also need to look at the forms of liability that may give rise to a remedy. And here we see some serious deficiencies in the reworking of Article 8, certainly without any explicit provisions on joint and several liability. And again, following on from Sasha's comments, bringing the provisions in line with domestic legal principles does water down what we had previously. Now, having said that, I think the chairperson rapporteur has had a very difficult task of bringing together multiple state views, considering also what went down at the 8th session. And I think they should be commended, despite shortcomings in the process, for putting together some very streamlined provisions, certainly on access to remedy. So just a couple of points, a few points here. Already starting from the perspective of rights of victims, the provisions for precautionary measures is very important, certainly for workers in global supply chains. And we would applaud its clear inclusion here. On access to remedy and Article 7, we see language around the progressive reduction of legal, practical, and other obstacles to access to justice, which is quite wide-ranging, which is good. But spelling out the need to restrict the use of forum non-convenience doctrine, for example, could be good. But again, the travaux préparatoires and the discussions we've had over the years should cover this. There's some improved language on facilitating disclosure and provision of information that we could build on that, certainly. And again, better language on the reversal of burden of proof. But again, this needs to be improved in terms of certainly reducing the evidentiary burden. Now, a key issue for unions, Carlos, and I'll stop momentarily, is, of course, on legal aid and financial assistance. Again, there's a good opening here, which we need to build on. As is the need for group claims. And I do think a fundamental piece here, which is very positive, is the meaningful consultation of victims and rights holders in the design and delivery of reparations and remedies. This is a really key piece, which I think would, which bodes well in terms of the discussions we're going to have at the end of October. Thank you.
Thank you, Ruwan, for those nuanced insights into the treaty. Let's move to Erika with the same question to finish with this round of general questions. Erika, please.
Thank you, Carlos. I will take us a bit back. I'll be brief, but I think that to talk about the updated draft, we need to shed some light on the process that led to this update. And this process has been marked with an unacceptable level of arbitrariness by the chair. So to remind us, I think you all remember that last year, less than 20 days before the 8th session, the chair published a set of informal proposals. So no states had asked for this. In fact, several states opposed it in the plenary, and still the chair imposed that the session of negotiations would continue in 2 tracks.
Erika, we don't have the time for that now. We have 3 minutes only for each speaker. Can you address the question?
I'll make my point on access to justice. The point is that given also what we've been hearing on from the other colleagues, that there's a complex task in hands of accommodating different provisions from states, when we look at the update, it's clear that some of the key proposals from several states have been removed. At the same time, proposals that were brought forward by one state only have been integrated, and some key provisions have disappeared without really a lot of explanation, and sometimes with no single state asking for it. At the same time, some of the chair's informal proposals have been, in a subtle way, integrated in the draft. So what does this mean in terms of access to justice? Not surprisingly, we can see that in several articles, this has been severely weakened. And I agree that we need to look at the treaty as a whole, not just some articles. So, for example, and it has been mentioned by Sasha, the consistency with domestic law, this really limits access to justice of affected peoples. We understand that the provisions on the reversal of the burden of proof on Article 7.5 have been weakened by the new language. We also lost, for example, the forum non-convenience on Article 9. The notion of forum necessitatis also has been weakened. And if we look at some articles related to legal liability and even prevention, we have a lot of due diligence inclusions here. So in a way, this updated draft is tending more towards guidelines for states to develop their own due diligence legislation rather than an international treaty that's aiming to reduce corporate impunity. So this will, of course, narrow access to justice. So we understand with the updated draft that the chair has significantly overreached his mandate and acting more as a judge than as a facilitator. So I will stop there. Thanks.
Thank you, Erika. Much appreciated. So let's move now to other speakers and or to each of you, but with the specific questions more related to your own expertise to benefit, to draw from this very strong background that you bring with you in terms of practice at the national and international level. Let's go back to Sasha for a brief moment. Sasha, you started already outlining some of the issues. Where do you think there remain the main problems or shortfalls with access to justice in relation to access to justice in the current treaty process?
Well, yes, indeed, I already started, and as much as I agree with having a comprehensive views, I'll have to select maybe some comments on some articles, just to say that Articles 4 and 5 set out a series of useful provisions, often restatements of international law regarding the rights and protection of victims, although we would prefer to use the term rights holders. But yeah, as I think we can consider that Article 7 to 11 are perhaps the core operational provisions on access to justice that try again to address typical gaps with regards jurisdiction, liability, statutes of limitation, or applicable law. I'll pass on the consistency with domestic systems, which I've spoken to before, but it is something that is very prevalent in these articles. If you look at Article 7 on access to remedy, I do think that there are important provisions here, some of which are clear and some interesting language. Yet I would note that the reduction, the provision on the reduction of evidentiary burdens has been weakened. There's no mention of the application of presumptions as to existence of certain facts, as was in the third revised draft, or the possibility to impose strict or absolute liability in appropriate cases. Again, and this was also cited by Ruwan, one of the greatest weaknesses in our sense are the changes made to Article 8. In general, the article is drafted in a somewhat confusing manner, which mixes civil, criminal, administrative liability without explicitly naming them. The link between the liability standard and the rest of the draft is not extremely clear to us. But maybe to cite two major issues here, Article 8.3 sets liability standards for a series of offenses that you would find in certain states' criminal systems, so conspiring, aiding, abetting, etc. The commission of a human rights abuse, but it fails to explicitly mention situations of direct commission of a human rights abuse. And second point is it's not clear anymore whether the paragraph setting specific avenues for parent company liability for harm committed in a company's value chain has been totally deleted in the text, or if this is a drafting mistake. In other words, To be honest and transparent, we're not sure if there should be an Article 8.7. If you read attentively the track changes version of the updated draft, it actually looks like there is an article in parent company liability, but it's not in the clean version. So here, either it's a deletion, which would be a very worrying step back, but even if you look at the article in the track changes version, it still is restrictive because it looks it only creates avenues for liability for controlled, managed, or supervised entities, which is more restrictive than the third revised draft, for example. And maybe just to conclude on Article 9 on jurisdiction and applicable law, Article 11, there are also issues here. Erika mentioned that there was a removal of a provision on forum necessitatis, which was in the third revised draft, which we regret. Regarding Article 11, it was in the third revised draft. It was not in the chair proposal. So of course, it's good news that this article be here. It's also good that there's a clear difference that's made in that article between substantive applicable law and procedural matters. But it's not very clear how this article will be read in the context of the restricted scope that I outline in Article 3.3, with instruments applying only to the scope being only the instruments applying to the state parties that ratify them.
Yeah, thank you, Sasha, for this enormous effort of providing an overview of the whole treaty. Very useful for everybody. Surya, please, let's expand on your, you already pointed out a series of discrepancies in the treaty in concept and operationalization. Do you think in terms of access to justice, the current draft, the updated draft facilitates access for affected communities? And if not, how could it be improved?
Thank you, Carlos. I would like to build on what Sasha mentioned and some of the concerns that he highlighted. I tend to agree with those concerns. I should acknowledge, though, there are some good elements. I think Ruwan highlighted that as well. There are good elements in the current draft that should definitely guide states who would like to take seriously the issues about access to remedy. There's no doubt about that. But the point is also things on paper and in practice. To what extent? Because some of these barriers and the solutions have been there, documented well in advance by so many organizations, but states are not taking those steps. So that is a separate question. I don't want to go further into that. But let me highlight three challenges. There are many challenges, but I will mention three challenges, because if this treaty has to add some value, it has to try to overcome some of these systemic challenges. One challenge I see is that when state agencies are violating human rights, what can victims do then? It seems this draft treaty, LBI, is assuming that there is a watertight compartment situation. There's a division between the government agencies and the private companies. But often, these state agencies are the culprit. Either they are actually violating human rights, or they are complicit with those companies. So in a situation like this, how could we expect those state government institutions to hold these state agencies accountable? That's one issue. Second is power imbalances. Well, these power imbalances are about information, expertise, proving burden of proof, or the whole power dynamics in terms of who is close to the power. I don't think this treaty does enough to address those power imbalances. And I think Sasha also highlighted, and I think earlier colleagues also highlighted that. The third issue I want to highlight as a challenge is how many cases do we anticipate we can take to the home courts, home state courts in the global north, let us say. Because the number of violations are in millions, I would suggest. We cannot take each and every case to the home states. So how do we deal with that particular situation? And now let me quickly mention some of the wish list. Maybe it is too late, but I would like to see the treaty talking about direct obligations on businesses. This is a serious gap. Second, the treaty should contemplate a strict liability, at least in certain situations. You cannot have a situation where everything is fine. There have to be certain red lines, and a strict liability is relevant, in my view, in certain situations. Thirdly, I would like to see more extensive references and explicit recognition of environmental related abuses and violations. Because at this point of time, when the General Assembly has recognized a right to a clean, healthy, and sustainable environment, we can't go in a regressive direction and just try to dilute or remove references to environmental pollution or other environmental harms. And of course, they are linked to human rights abuses, but they have a separate aspect as well. And my last point, and I will conclude with that, Carlos, and that goes back to my hodgepodge point that I was making earlier. Liability for what? Is it liability for not doing due diligence? Is it liability for doing due diligence properly? Or is it liability for that you did something that resulted in abuse of human rights? So I think we need to clarify this, that what are we talking about here? Thank you very much.
Thank you, Surya. I think you have pointed out something very important now with this issue of liability and the link with access to justice. So, and thanks also for the wish list. It's never late, especially in international affairs, not only to formulate wishes, but also to work and with different agendas. So thank you. Let's move to Ruwan. Ruwan, you are bringing with you enormous experience and representativeness in terms of your work with the trade unions. And so this current draft takes sufficiently into account the workers' and union demands, and for better access to justice in the context of supply chains, abuses in the supply chains?
Yeah, thanks, Carlos. So I think for the global trade union movement, when we started engaging in this process, it was very much geared towards access to justice and remedies for victims of transnational corporate human rights violations. And for us, one of the key issues we've been facing over the years in trying to initiate litigation is the use of the separate entity doctrine, which has basically converted multinationals into networks of national level entities, often poorly capitalized and judgment proof. So for us, the proof in the pudding will really be how we can reverse that in favor of victims. So at the risk of repeating myself again, I think here the sources of rights are critical. And what Surya alluded to earlier in terms of dropping any mention of environmental harm and the relevant international norms is hugely problematic, considering that for workers, a just transition to a green economy is one of the key issues, and we're seeing major layoffs without consultation, etc. So this is really a key problem. Now, if we are looking at this right now from the lens of Article 6 on prevention and human rights due diligence being a major part of this treaty, which certainly should not be the only, the main provision, again, what we find problematic here is a lack of language on penalties for not meeting HRDD obligations, which we would argue is a separate and complementary obligation. That's out. Similarly, there's no provision for a monitoring mechanism where workers and civil society can also be involved. So that in itself is problematic. Now, in terms of the remedies themselves for workers, a key issue that's missing for us is the lack of a remedy in terms of reinstatement in employment. Reinstatement is a critical measure, especially when workers may be laid off or sacked, save for trade union activity. Now, moving on to the procedural side of things, as I mentioned earlier, there is some progress in the language, although albeit streamlined. For us, access to information in litigation is absolutely critical. And I think we have to have certainly more in terms of information relating to corporate relations, their financials, even in trying to identify the entity to sue, which for us has been a major problem in litigation at the national level. Similarly, the need to reduce the evidentiary burden and to facilitate group actions. And of course, with this comes the need for financial assistance and legal aid throughout the process. And I think that these are areas that we can start to build on. Now, in terms of jurisdiction, we've noted the lack of forum necessitatis, which is previously contained in Article 9.5. But similarly, again, the idea that you can claim jurisdiction where a company has a significant, so in a place where they have the principal place of business is certainly not adequate in terms of the ability of corporations to move their seats to, say, certain countries with weak governance regimes. So that needs to be built on. Another thing from a worker perspective is on limitation periods. While Article 10 certainly is progressive in some ways, we do see a need to extend limitation periods for what we might not call egregious human rights violations. For example, in cases of industrial disease, or in discrimination claims or claims for gender-based violence and harassment, for example. So those are just a few things which we think can certainly be improved. But needless to say, again, we have to treat this in a holistic manner, and we're not even talking about the enforcement mechanisms or the monitoring body for the treaty, which in itself will be a critical source of a remedy for victims and rights holders. So I think at some point we do really need to be focused on Article 14 as well. Thank you.
Thank you, Ruwan. Thank you for this pointed remarks. Before we move to Tony, let me remind you to the audience that you can leave your questions in the Q&A part of your screen under the image, not in the chat. There will be no time actually to give the floor to interveners, not to formulate questions. So I think it's important that you write your question there. Tony, let's stay with you. Welcome to the discussion. Also on the link that Surya and Ruwan and Sasha have already addressed between legal liability and access to justice, a very important link, of course. And you have many times discussed and emphasized the question of joint and several liability as part of the treaty. So could you elaborate on that? Do you see that in the current draft? And what does it need to change in the draft to incorporate that concept? You have
Thank you,
Tony.
Sorry. Thank you, Carlos. Yeah, unfortunately, I don't see it in the current draft. I hope I'm wrong, but I couldn't see it. There has been proposals by a couple of state parties to have joint and several liability, but apparently it has been rejected. No, by joint and several liability, that means basically that you have more than one respondent to a case. So, for example, you have the transnational company, you have its subsidiary, you have its subcontractors, and everyone throughout the global value chain. So what that means is if the union, the workers, or the community gets an award from the court, the entirety of the award can be imposed only on the transnational company, and it's up to them to divide among themselves who is liable for what percentage of it. So it shouldn't be the burden should not be placed upon the victims, the workers, and the peasants to divide the liability among the different respondents, and that goes into the heart of what we're trying to do in this treaty. What we're trying to do in this treaty is to make the transnational company responsible, because at the end of the day, it is really the transnational company who's in charge of everything. Let's just recognize the commercial reality. It is the transnational company who has the intangible property, the intellectual property, the brand, etc., etc. At the end of the day, it's the transnational company who gets most of the value out of the entire enterprise. It's not the factory, independent factory in a third world country making shirts or making shoes. It's at the end of the day, it's really the transnational company. And let's not forget, although the subcontractors and the suppliers are so-called independent, everything comes from the transnational company. The design of the clothes, the thread that has to be used, the color, etc., etc., the marketing, the goodwill, etc., etc. So we are now in a situation where everything is globalized. Once upon a time, everything was made by the transnational company. It's in its own backyard. Through the years, they were able to subcontract it to, I mean, all throughout the world using global value chains. At the end of the day, these global value chains, these suppliers and what have you, are committing human rights violations and labor rights violations for the company. It's as if these so-called factories are actually directly employed by the transnational companies. And company owners are nothing more than subcontractors and supervisors. So it's very, very important that we have joint and several liability, because without this provision, I mean, everything is for naught. This treaty will be totally useless if the transnational company can just say, well, I did everything. It was the third world company who was making the violation, who was committing the violation. It was my subcontractor who was damaging the mines and the environment. So I should, at most, the transnational company will say, I should be liable for only 10%, 15%, 20%. But no, with joint and several liability, they should be made responsible for 100% of the damages done to the community, to the workers, to the unions, etc., etc. Thank you.
Thank you, Tony. I'm very poor timekeeper, and I realize now that we are running out of time in terms of the main part of the discussion. So let me accelerate and let's move to Sor.Rattanamanee from Thailand. Are you with us? I think so, yes. Sor,
yes.
As a practitioner working with the local communities in particular, give us a few examples of barriers to access to justice. And why, what difference a treaty would make in terms of people, overcoming those obstacles. 4 minutes, please.
Thank you. Yeah, I think actually because of with the local cases in Thailand, the problem of we don't have the subsidiary law for any get responsibility from the a mother company. Then this is very difficulty for whenever the small company collapse or broke up, something like that. And then if we want to get the remedy from them, then we cannot get anything. Even they are subsidiary from the big company, because of under the we have only agent law, and under our agent law is not make any responsible for the subsidiary company, because of under our law, the company, when they register as a company, then they are different person. They are not the same, or like a mother or son, something like that. This is very difficult. Then and a lot of company now they get benefit by, have a big company, and the big company have their own like a small company in the different sector, and then almost of the small company doing the violation, and then after that, if there is something like the mining case that we have, this is also the bankrupt, and then after that, the big company that get benefit from the small company, they not respond anything, and we cannot reach them. This is one. I think when we have the treaty will help us to at least we can request it to our government. If the government ratify, then we can ask them to implement the law for the subsidiary. That is the one. And the second is even we don't have like a implementation for the law, because anyhow we can make it how to say the idea for the judges to understand what the responsible of the company for the cases. Then we can also try to make the agent law to make it more, how to say, open and also expanding to get responsibility between the company, the mother company, and also the agent company, something like that. This is the one that we see. Anyhow, with the civil law system as Thai law, it's not easy to apply for the treaty directly to our cases because of the judge used to say that, oh, sorry, it's not implemented. It's the international law we cannot use. But as a lawyer, we also used to apply the idea of the treaty to make them understand how the access to justice have to apply for the victim to protect the victim. That is the way we can do it. Yeah, thank you.
Thank you, Sor, especially for your conciseness. Yeah, well, we'll come back to you in a minute with more general questions. But now let's move to Letícia. Letícia Aleixo from Brazil. Letícia, why is it important for affected communities that we have a treaty that includes them in the process of consultation and the drafting? Well, what difference does it make for them at the end?
Thank you, Carlos. Well, we all have a lot to learn from communities affected by business activities, both from their resilience, but also from their wisdom. They are the best people to tell us about the damage they've suffered, the reparation measures that they may consider appropriate, and so much more. In one of the cases I worked on related to the collapse of a large mining tailings dam in Brazil, a lot of time, money, and effort would have been saved if communities had been placed at the center of the reparation process from the outset. So much had to be redone over almost a decade because of lack of outreach, of effective engagement with communities, and also because of lack of trust. And in the same case, I believe a treaty could have made a big difference by bringing particularly clarity related to jurisdiction or even to the rights of victims. There are thousands of lawsuits related to this case in Brazil seeking redress, and many of the victims are also seeking justice transnationally through litigation in the United Kingdom. So just deciding on British jurisdiction over the case took years, 4 years, I believe. So I hope that the treaty will be able to guarantee access to real justice for victims around the world with reasonable time frames, deadlines, etc. And the treaty is also an extremely important tool for affected communities, as it prescribes the right to individual and collective reparation in various forms, including ecological restoration. Almost 8 years on from the collapse, some families still complain that to this day they are unable to resume their traditional ways of life, linked to fishing, for example, and they also live with uncertainty about the quality of water that supplies their homes. So it's really essential that reparations integrate human rights and the environment, both because of the importance of ecosystems for human beings, but also because of the inherent value of nature itself. And finally, I believe that the involvement and effective participation of affected communities in the treaty drafting process has the potential to generate more awareness and empathy in negotiators who are often very distant from local realities.
Yeah. Okay, but the affected communities, are they aware of the treaty process? Do they even know that there is a new updated draft? Sorry to ask you this, because I suppose many people ask the question.
in a short sentence, I think it's really hard to translate like the technical language and the process itself to communities. But in those communities where I used to work, they are aware that the UN is trying to negotiate like binding standards for corporations and states that could protect them, and they are even like trying to make suggestions, and sometimes they contribute in some of these events. Yeah.
Okay, thank you, Letícia. We'll come back to you. Let's move to Erika. Erika, I think for years you've been proposing and presenting your ideas of an international tribunal for transnational corporations. But looking at the current state of affairs, no, the record of international justice and national justice and the current draft, I have two questions for you, a bit provocative. I'm sure, but I'm also sure you will not mind this being provocative. On the contrary, you will like the kind of question. Do we really need an international tribunal for corporations, transnational corporations? And can we realistically obtain it? Let's make your case about this. Thanks.
Thanks, Carlos. Yes, there's always lots of questions around the tribunal, right? And it seems this very ambitious demand. So first of all, it's not a proposal from me, for sure. So the ideas that I will present here are based on a lot of collective work throughout the years of many different people, movements, organizations that I've the privilege to work with. So in particular, Friends of the Earth Africa, the Global Campaign. But there's also proposals coming from other places, right? So for example, the Elements paper even included some language that state parties may decide that international judicial mechanisms should be established, for instance, an international court on transnational corporations. This language was completely lost in subsequent drafts. And even earlier than that, in 2016, there was a paper by Luís Gallegos, who has chaired the working group, and Daniel Uribe, entitled The Next Step Against Corporate Impunity, a World Court on Business and Human Rights. There's been some proposals around, and it seems that when we talk about a tribunal for transnational corporations, it seems like a very ambitious demand. But when we hear that there are, for example, arbitration tribunals that can award multimillionary penalties on ISDS cases to companies, then they were just created as a parallel legal system. So I think if there's political will, for sure, it is realistic, but we know, of course, there are many challenges. So we understand that we need an international tribunal on TNCs because we need to ensure that the effective implementation of this treaty. So otherwise we risk having a document of good intentions, but not executable. So also making a parallel with what Surya Deva was saying earlier. Is it about intentions, or is it about also implementing? So we understand that the treaty needs to count with an appropriate judicial mechanism, an international tribunal, that needs to have jurisdiction over the companies concerned, that needs to have the capacity to monitor compliance. And then again, the very important point made by Surya Deva on direct obligations. We need to have direct obligations for transnational corporations in the treaty. It's not about just re-emphasizing state obligations. And of course, the treaty needs to sanction non-compliance as well. So what we, I don't know if, Elodie, if you could share the covers of the proposals we have, if that's possible. If not, then it's also fine. So we have made a proposal launched a few years ago in 2018 by Friends of the Earth Africa, which is this document on the left, A Tribunal to Live. And then as Global Campaign, we've also made a publication, basically where we outline what could be some of the basic, the statutes of an international tribunal on TNCs under this legally binding instrument. So the essential elements that we are proposing is, of course, the tribunal needs to have jurisdiction over transnational corporations and other business enterprises with transnational activities. So according to the mandate of the resolution 269. We also understand that the tribunal needs to be governed by the principle of complementarity. So its actions would be complementary to states' jurisdictions. However, the statutes must allow the tribunal to exercise its jurisdiction also if the state or states concerned do not act appropriately according to domestic laws and international human rights, labor, environmental standards.
Erika, where can viewers or the audience can find this document?
I will paste the links in the chat so you can see.
That will be useful because since we don't have time now to present the whole proposal, maybe people can go and consult it online if you provide it.
No, for sure, to see more in detail, I would urge you to look at it and even give some feedback. So I will just focus on some of the main issues that I think are quite interesting. So for example, of course, we defend that the centrality of the rights of affected peoples needs to be the compass of this tribunal. So one of the aspects is the treaty must ensure, and the tribunal must ensure, cost-free justice for affected peoples acting on their behalf. So this means, of course, that it could create a legal support mechanism for this purpose. And then finally, to close, one interesting element that we are proposing in this tribunal is that the seat of the tribunal, so it needs to be a permanent tribunal, and the seat of the tribunal needs to be in a country of the Global South. However, we understand that to facilitate access to justice, especially to affected peoples, we also propose the tribunal to have an itinerant jurisdiction. So the tribunal should have the opportunity and the ability to hold sessions elsewhere, including having itinerant sessions in any region of the world. So this would mean sessions also closer to the people who are affected by companies' activities. And this is also inspired from the example of the Permanent People's Tribunal, for example. So both of these proposals are living documents. We will continue strengthening, improving the demands as we advance in the process of negotiation. So I invite you all also to have a look and give any feedback, comments to strengthen the proposals or criticism. Thanks.
Thank you. Thank you, Erika. That was a wonderful summary. Let's move now to the last part of this session. I have a general question for three of you, for Tony, Sor, and Letícia. In terms of, I would like to, I think everybody would like to hear from you just one key element that will make this treaty more instrumental in facilitating access to justice by affected communities. Let's start with Letícia.
Carlos, this is a hard question because I think there are many aspects that cannot be left out of the treaty. And I agree with many points that colleagues have already mentioned, such as the strict liability, the recognition of power imbalance, and reversing the burden of proof, for example. So I think I'll take this opportunity to highlight how essential the provisions on prohibition of intimidation, harassment, reprisals, and re-victimization are. And this unfortunately happens all the time in local communities, affected territories. Last week, one of the community leaders was arrested on charges of defamation. He lost everything he had during the collapse, the dam collapse. And for 8 years, this person and his family is living in a mostly temporary housing with leaks and unsuitable land for his work as a small rural producer. And he was tired of ineffective work carried out by the company on this land. And he decided to forbid the workers from starting new intervention and spending more money in this provisional home because he prefers the money to be invested in his final home. He wants to resume his life. So the company called the police on the family that has been waiting for reparation for 8 years. And that's why I think these provisions about the guarantees for defenders and leaders are so essential. So it's really important for the treaty to be able to assess and be really effective on this issue, as well as to guarantee the independence of the reparation process that cannot be handled by corporations, so that re-victimization does not happen anymore with affected communities, I believe.
Okay, thank you. Thanks, Letícia. Tony?
Yeah, thanks, Carlos. Yeah, maybe what we should have is some sort of hard law for us, for the unions, for the communities, because we have noticed that for corporations and others, investors, what have you, they have hard law. They have the WTO agreements, they have free trade agreements. Erika mentioned investor trade dispute settlement, etc., etc. We lose our farms, we lose our jobs because of these trade agreements. But when it comes to us winning at the ILO, there's nothing. I mean, the ILO can just try to convince the governments to comply, but we have nothing at all. So it's really high time to have an equalization, so to speak, as between hard law also for us, for the communities and the workers and the peasants. The second thing, though, is concurrent jurisdiction. Erika mentioned the International Tribunal. There should be concurrent jurisdiction between the International Tribunal and the tribunal inside of the home country of the transnational corporations. It shouldn't be the case that, you know, the jurisdiction of the rich country will just say, well, it's none of our business because the atrocities were committed in another jurisdiction. That shouldn't be the case. There should be concurrent jurisdiction, and all of the states should bind themselves to have concurrent jurisdiction with respect to these types of violation, both at their own courts and at the international court. Thank you.
Thank you, Tony. And last, then we have Sor. Hello. Yes.
Yes.
Sor, indeed. Sorry.
Yeah, I think I have two two issue that I would say that if we have like the treaty, at least because of Thai government very responsible with the business and human rights issue. I mean, after UNGP, and then they adopted and apply as a national action plan, and now we have the second national action plan on business and human rights. And I hope that the treaty will make more effective to get the implementation for the Thai law. And what we want to see is about I already talk about the subsidiary issue. And the other one is also supply chain. We also know that it is very difficult for getting remedies for the access to justice for the community who affected from the supply chain, because of we also know that the small company, they cannot respond anything, but the benefit is with the big company, how we can bring it. And I hope that the treaty will the treaty will do this thing, and then the Thai government, or I think other government may be responsible, because of when they ratify, at least we have a tool to pull up our government to apply this law to support and protect the people from the corporate, to make the accountability. Thank you.
Thanks, Dora. Thanks for pointing to the important element of implementation and implementability of international solutions. Clearly, that's an important point. So with this, I will close this panel. I think I'm unfortunately run out of time, run well over the time allocated for us for this discussion. So I will, without much summary from my side, I will hand over to Elodie to see if there are any questions from the audience, and eventually let you, the panelists, answer those questions. Elodie, over to you. Thanks very much to all, and I'll continue discussing.
Thanks, Carlos, and hi, everyone. So we have some questions in the Q&A box, and I encourage you to use this as well. And please direct it to a speaker that would make it just a bit more efficient. So there's an interesting question about the fact that some businesses do not intend to commit human rights violations. Often it's a consequence of a short-term profitability, and they're making a parallel with corruption. So I would think maybe Tony could respond if there's a cross-recognition from the treaty to international anti-corruption commitments.
Yeah, so that's the reality in many countries, especially in third world countries. No, there's corruption and what have you. There are challenges in the judicial system, but these should not be excuses for transnational company to actually police their ranks and ensure that all of the firms all throughout their global value chains are actually compliant with human rights, with the core ILO standards, with environmental standards. So the only way to make transnational companies liable is basically, I mentioned earlier before, no? But by making them jointly and severally liable. The transnational company should be liable for all of those committed, in fact, on their behalf and to their profit, to their economic advantage, no, committed by their subcontractors and subsidiaries in third world countries.
Thank you. Does anyone want to add anything on this question? Go ahead, Surya.
Thank you. I think I will just add that we should also look at addressing the root causes. And I think one of the root causes is that the corporate law has to be changed. And I think this treaty has a role to play there, because unless we redefine the very purpose of corporations, because the real difficulty is that there are incentives for the corporate leaders to maximize profit in the short run, because their remuneration is linked to how much profit company makes. They release quarterly return statements and all that. So all these structures of corporate law and financial law create incentives for businesses to indirectly or directly violate human rights. And I think we need to address those root causes as well. Thank you.
Thanks, Surya. So, and linked to this as well, we have another question about how or what provision does the treaty make to deter businesses to commit violations? And, you know, the person is inquiring about criminal liability, which, you know, that's, we're kind of a step a bit far from that, but could one of you elaborate on this type of provision? Sasha, please go ahead.
Yes, thank you for the question. I'm just going to maybe paste two relevant paragraphs of the treaty as a response. Yeah, sorry. So because basically Article 8.3 and other articles do establish liability both for legal and natural persons. So that's I guess a first element of response. And 8.3 does speak about offenses like conspiring to commit human rights abuses, aiding, abetting, facilitating, like basically complicity also. And 8.6 speaks about establishing effective, proportionate, dissuasive penalties or other sanctions. So I guess in part these things are within Article 8, which, as we said, could be also amended to be maybe a little stronger. But the part on contracts, I don't know if that refers to contracts given by the state to corporate entities, but I just want to mention that the role of the state as an economic actor which does have relationships with businesses, does, yes, provide contracts, export licenses, these kind of things, is not very well addressed in this treaty. And we would think that it would be good to have more provisions on how the state as an economic actor has responsibilities or also can act to prevent human rights abuses in Article 6.
Thanks. Anyone else from the panelists would like to comment on that?
If I may, yeah, I think the treaty also envisions criminal, civil, and administrative liabilities. So it's a comprehensive, set of liabilities to which transnational corporations could be made accountable. I mean, so hopefully that would be a deterrent.
Thank you. And so we have another question about clarification, because we've been talking about affected communities. And so, this person is saying, oh, but it's vague because indigenous peoples have a clear set of rights, and also there are affected communities. So what do we mean by affected communities? How do we differentiate with other kind of specific and as they're referred to also in the draft, vulnerable people. So perhaps I think maybe Surya or Ruwan as well, with the workers' perspective, could respond to that. Or anyone else.
I'm not very clear about the question, to be honest, but I personally do not feel comfortable with the terminologies used in the treaty of the victims, for instance. I would consider that we should think of human rights and the rights holders. And then the interest of those rights holders are impacted by business activities, by the government actions, or omissions on the part of the government or the companies. And there should be an access to remedy, and in fact, actual effective remedy whenever those rights of the holders are violated. And the last point I would like to make is that some rights are collective. And I think that's where the communities become crucial. So I would say individual who are the bearers of human rights, and then there are collective rights, especially, let us say, self-determination, even environmental rights can be regarded as collective rights, So those issues are of great significance in relation to the communities. So I think these are my remarks. Thank you.
Thank you. Letícia, do you want to comment on that as well?
Well, I agree with Surya, and some of my colleagues have already mentioned this flaw in the treaty in Article 4.1, I think, when defining victims of human rights abuses. So I tend to agree. But just to clarify, in case there is any doubt about the case I was mentioning, indigenous communities are also affected by the dam collapse here in Brazil. So, of course, they need reparations appropriate to their spectrum of rights and worldview, but the treaty should be broader than not only to address these kinds of collective rights, but all kinds of rights that any right holder, individual or collective right holder could have or could have been violated in this case or in many, many others.
Thank you, Letícia. And we had 2 more questions come in the chat. Unfortunately, we're running out of time. So if, one is about the tech sector's involvement, and then other rights, like more from a gender perspective. So in case, speakers want to take time to respond directly in the Q&A, that would be great. But, in the meantime, I just really want to thank you all very much, especially our speakers, Carlos as the moderator, all of you as well who have attending the webinar today, and also previous ones we organized. So we really hope you enjoyed hearing from experts on various key issues on the treaty process throughout our webinar series. The recording will be available shortly along with the recording of the other 2 webinars. And I'll take also the opportunity to just letting you know that as the 9th session of the Intergovernmental Working Group approaches, the Business and Human Rights Resource Center will continue to monitor any developments linked to the treaty. And we have launched a new blog series called Building Momentum, Critical Considerations in the Binding Treaty. And I'll put the link in a minute in the chat. And so there, experts are going to really reflect on the updated draft and also their hopes for the session. While this is all ahead of the treaty session, then during the session, we will also produce daily updates to ensure that stakeholders are aware of the decisive moments in the negotiations every day during the week. And this is also to support allies in their work to hold companies accountable about human rights abuses. So once again, thank you for attending and participating, and have a nice rest of the day or evening as well. Thanks very much, everyone.